A very warm welcome in the fourth module of week 1 of the course Entrepreneurship and IP Strategy, titled Whether Entrepreneurship and IP Related? What is the role of IP strategy in entrepreneurship? Earlier we discussed what is entrepreneurship, and then we in the next module we have seen that what do you understand by IP. After going through the last module titled what do you understand by IP, you might have appreciated various types of IP and related acts. Probably you might have perceived the vast nature of IP field. Now, we will check the relationship between entrepreneurship and IP strategy. Now, in this module that is titled what is entrepreneurship, in the earlier module, that is what is entrepreneurship, we have tried to understand that when we have given you the example of the various organizations, we have given you the idea, okay, this is the organization and this is the important IP. Obviously, it is very clear that any organization you take, all four types of industrial property, that is patent, trademark, copyright and industrial design are very much important. But still what we have given you the idea that okay, this is the organization and this type of IP is like a very prominent here. So, you can relate the IP very easily with that particular organization. So, you can get the idea, okay, this is entrepreneurial activity and this is the IP involved here in this entrepreneurial activity. So, that we have done in the earlier module, that is what is entrepreneurship. Now, in this module, we will go in little detail about this, what is entrepreneurship and how exactly IP is related with entrepreneurship. So, let us begin here. Now, the question probably in your mind is, really these both areas are related? Because in your engineering or science curriculum, whatever you have gone through, maybe you have got little exposure about IP, I am assuming that, and probably you may not be aware that IP is such a vast area, and probably you may not able to relate that your understanding about that your core subject and the this IP area. So, what probably you may never have thought that okay, this IP is so related with my core area like a science or engineering. So, we will try to understand that, and I will give you that one example here, so that you can easily relate that okay, yes, really IP and entrepreneurship is related. Now, here the example which I can give you is related to upcoming technologies like artificial intelligence or blockchain. Now, here what the thing happened that when you are that technology is developing, what the thing is happening that IP laws are like becoming that very challenging, because what the thing is happening that whatever the what we can say the guidelines are given for any invention to be considered for IP protection, that certain guidelines are there, and sometimes what happen that particular guidelines may not match with the that particular technology which is upcoming. For example, artificial intelligence is a little bit what we can say challenging one. Now, suppose you are working in that area. So, what we can just see that one simple example, that you are using your artificial intelligence related domain knowledge and you are creating something which is very what we can say innovative. And the question is who is the owner for that creativity, because when we talk about IP, we try to understand who is the owner and who will have that legal rights, right. Because the thing is that already we have said that we are in a technology, what we can say technology is moving fast and we are in a knowledge economy where that particular knowledge is creating what we can say asset, and if it is a asset, who will own that asset, that is very important. Now, think that a machine you have created it, whether that machine will own, because that machine is doing or robot is doing that particular activity. So, the question is the person who has created that particular robot or that particular machine, whatever it may be, or that particular machine, who will own that particular IP right. Now, just simple example, I can one more elaborative example that you can appreciate it easily, that if suppose this incident happened, that car accident by a driverless car. Now, if this kind of scenario happen, this is your artificial intelligence and you are using that algorithm, and by using that particular thing, that that car is going on the road, and it suppose that driverless car, there is an accident, there is no driver, otherwise generally what the thing will happen, either owner of that car or that driver, they will be liable for that particular thing. That is a general what we can say understanding. Now, here the question is to whom you will we consider responsible for that particular thing, whether that car maker or the machine that is in the car which is doing that particular activity or that automation, or group of people who are involved in that technology development, who will be responsible for that particular thing. Just think over that to whom you will, in this case, who will be the responsible. And therefore, what we can say that in the fast paced technology, as it is a very competitive advantage is there because of that fast moving technology, complexity of law is also what we can say increasing. And we have to understand, yes, this is a technology, and yes, who is owning that particular the output of that technology and who will get that rights, that is very important. And we have to appreciate that this intellectual property is giving you that particular rights. So, I guess this is good enough to understand that yes, IP, that is a which is a creation of what we can say, it is an invention or innovation, that creativity is there, and that creativity is like a protected by IP, that is an instrument, and that particular protection gives you the ownership, whosoever is applying for that IP, that will get the ownership. So, I guess this is good enough for you to give the background about that particular entrepreneurship and IP are definitely related, and we will see a few more details about that. Now, unlike tangible assets to your business such as physical infrastructure, building, or that is a physical assets, right? This intellectual assets are also very important, and we can say that in current scenario 80% or more are intellectual assets, and generally this physical infrastructure is 20% only. It is a completely what we can say, you can understand that that much importance is given or that much importance is gained by that intellectual assets. So, there are 4 ways by which you can what we can say protect your technology, and these 4 ways in India are like patents, trademarks, industrial design and copyright. So, we have a dedicated modules for each of this type of IP because these are coming under a industrial property. So, at that time you can go in little bit more details about this particular intellectual property types. Now, this can be valuable to entrepreneur in a variety of ways, such as it will help in development and refinement of the product, or providing protection, developing branding and marketing material, and maybe sometimes like surveying competitors activities, because now probably you may not able to relate. For example, branding, marketing, trademark will come into picture. Surveying of competitors activities, patents is a very good what we can say, by which you can keep watch on your competitors. Then the other example is like a refinement of a product. Obviously, if you do the patent search and analysis, definitely that will help you to refine your product. So, that way this 4 types of IPs will definitely help you in what we can say development of your entrepreneurial activity, and obviously they are giving you a competitive advantage. So, people you say that there are ideas, and that ideas come from existing that businesses through research and development. That particular idea selection is there, and then R&D goes, and then what we can say that particular maybe service or product is developed. Now, if you take an example of Apple, they have an established technology company, right? Now, they have developed iPod. Now, they have realized the necessity of iPod by understanding the scenario in the what we can say market, and they have developed that particular iPod. Right. Now, these ideas that are generating what we can say the value to the economy by encouraging people to buy and invest these new developments. That is that new developments in the technology. There is a market push and market pull kind of what we can say, these two concepts are always there. And here what the thing happened, that entrepreneur is pushing his invention into the market, and maybe if they are very good, customers are going to buy that particular thing. And how this technology is moving and it is getting what we can say market share. So, here whenever you are moving into technology, if you are protecting it with the IP, probably that will give you the competitive advantage, and it will be very easy for you, that monopoly which you have received due to the protection, that will probably keep your competitors away from your what we can say competition, and you can be a leader in that particular technology. Now, here this what we can say this intellectual property is giving a sole ownership, and these owners can control the use of intellectual property to create a wealth, and that ownership is for some limited period of time. We will see that what is the time period for that every IP, because it is different. For example, patent it is at 20 years. So, for that 20 years, that sole ownership if it is there, you can probably what we can say explore that particular technology, and you can get the advantage in the market. Now, we have seen that what is entrepreneurship is, but when we are talking about an entrepreneur, he is like a person who is developing that entrepreneurship, and he is investing. It is a high risk, right, and that large funds are invested there. And if that investment is there, it is expected. For example, I give you a simple example. If a pharma company is there, to get a single molecule which is very positive, which is giving a positive result, probably they spend 10 years or 20 years or more than that, and huge amount of investment is there. Now, you just imagine, if I am just giving you one example of a pharma company, that huge, that years together, decades together they are investing, and if they will not get return of that, obviously that is not giving encouragement or motivation for that what we can say new developments in the society. And in that way, intellectual property is giving the protection and monopoly to that inventor and that organization who is investing the time, energy, money for that particular activity continuously for years together till that final result comes. Or sometimes any researcher, if you see, they are investing their life in that particular technology. So, obviously, the what we can say the philosophy is that inventor should get benefit, and at the same time society also should get benefit. And if you see the IP law system, this philosophy is completely balanced, that yes, inventor also will be benefited and society also will be benefited, and that balanced what we can say the rationale is kept when the IP laws are drafted. So, here what we can say that this IP law, so as an entrepreneur, when you are doing that entrepreneurial activity, yes, you are investing your maybe 10 years, maybe 5 years, your learning is completely what we can say you are investing that particular learning into development of that particular activity. Again, you are trying to generate funds to do that particular activity. So, here both time, energy, money, everything is invested, you are taking high risk and you are trying to develop that particular entrepreneurial what we can say venture, your venture you are trying to build. Obviously, you will expect there should be some protection for my idea which is now conceptualized and which is now in the form of prototype, and I am creating product or process or service, whatever it may be, I should get some protection so that I can be a leader in the market, and that way IP is playing the important role, that it is giving you that protection, and by that protection now you are able to build your venture. So, that is the what we can say importance of IP, and therefore, trademark is building your brand. When we say brand management, you have a provision in IP that okay, you register your trademark and trademark is giving you protection, or you develop that technology, protect it by patent and get that monopoly for 20 years. Or if you are in a publishing or film industry, you are creating a nice what we can say tune is there or musical notes are there, and that particular thing you have created, right, or some lyric you have written or some song you have written. So, you need that protection and copyright is giving that particular protection. Or suppose you are in the design industry, so automobile industry you are, or maybe you are in any product industry, whatever that packaging bottles are there, or when you talk about automobile, that car design is there, obviously people are investing time and energy to create that car design. Or if you are in a say electrical engineering domain is there, you see different varieties of fans or different varieties of bulbs and all that kind of what we can say units are there. So, all these are protected by industrial design. So, you can just relate that okay, these are the type of IP and these are like a creativity or and that particular you can protect by IP as an instrument and you can get advantage of that particular protection for a few years, so that you can be a market leader. As an entrepreneur, you may be a sole trader, you may be a partner or you may be a company. Yes, you anything any of this category is there. There is a provision in IP law to get protection and you can get protection as company or you can get protection as an individual. There is a separate provision as a startup. So, that what we can say provisions are available in the law. Now, next is like you here, as already I have discussed, that you are safeguarding your investment by IP, which is a legal instrument, and you are getting that particular protection. And here I will give you a simple example or a little bit what we can say history, that how exactly IP come into existence. Not all, just one example I can give, which is very related to you. That Paris Convention that was adopted in 1883. It applies to industrial property in a widest sense, including the patent, trademark, industrial design, and we do not have utility models, but it is in USA. Then service marks, these are the types of what we can say trademarks. Geographical indications are there, that is a very good dedicated law, very interesting law it is, and it is a very useful for a association or a group of people. And then there is also the arrangement for reparation of unfair competition, and Paris Convention is taking that particular what we can say care about that particular what we can say the activities which are, and these are the activities which are related to these different types of IPs. Now, how this come into existence is like at that time 1883, that time entrepreneurs, they have created some products or services, and you know that trade fairs are there, right. And in the trade fair, what this inventor or creators do, they used to exhibit in that exhibition, they will showcase their the product or service. And there were chances that yes, you showcase that particular thing in the exhibition, somebody who is visiting that exhibition, he can just see that particular product, and if he is in that particular domain, chances are there that he will buy that particular product, and you do reverse engineering probably he will do, and he can create that particular what we can say product on of his own. So, what will happen? The person who has invested say a huge amount of time, energy, money in short time, by giving a certain money, that particular person is buying that, he can do that work on that particular product, and he can have a product in a what we can say little time without much efforts. So, that was what we can say the worry to entrepreneurs, and therefore, they said that we will not participate in the exhibition. And at that time it was decided there should be some provision, and then the Paris Convention come into existence. And yes, we are the India is a what we can say signatory of a Paris Convention. So, you can just see how it is, how that system IP system came, and yes, it is related directly to the entrepreneurs who are creating that particular products or services, and there is a need of a protection of that particular creation. Now, there are certain rules, regulations, and WIPO, that is World Intellectual Property Organization, which is a part of UNO. That organization is taking whole care of IP all over the world, and you can see that this is the only what we can say, I can say that this is one of the what we can say important what we can say law that is harmonized, means IP law is like you go USA, you be in India, you may be in Europe, this law is harmonized. So, you get a what we can say same type of procedure and rules, regulation. So, that act is very similar, and we can say that harmonization of IP law is possible because of WIPO. that is a World Intellectual Property Organization. And therefore, it is very possible that okay, I am when I protect my patent here in India, yes, I am getting a territorial right for 20 years in India. If I want to do it in USA or in Europe, I can do sitting here, and yes, I am getting again the same rights in USA and Europe. So, that is what we can say the importance of that organization and how it is handling what we can say IP laws all over the world, because they have given certain guidelines, and TRIPS guidelines are there, and every country, almost every country in the world are following that particular guidelines. So, that is an advantage of that having the all IP laws. If you see in countries, these are similar. Now, when we are talking about areas which are related to IP areas related to entrepreneur, a few areas are you can see here that IP audit is there, patent informatics is there, or patent informatics or analytics is there, IP valuation is there, then IP and bank loan is there, IP insurance is there, technology transfer is there, and yes, as an entrepreneur you are going to do all these activities. So, in all way means you are going to do valuation of your IP, you are using patent informatics for your venture, and you will require technology transfer, you will require IP insurance, and yes, you can get the loan from your IP. So, probably you may not be aware about the details of that, but you can just you can get this idea once you go through this course, and you can appreciate that how yes IP I can use this IP for this different what we can say activities. Now, if I just try to give you few examples in a what we can say briefly, IP audit is there. When we are talking about a IP audit, suppose you are an entrepreneur and now you are doing your entrepreneurial activity. You may not be a startup, suppose you are already matured what we can say entrepreneur, and you will see I am not seeing any IP in my what we can say domain. Yes, there are chances that without IP also, yes, that is not necessary that in every business IP will be involved, but there are chances that if you are a technology related entrepreneur, you are running that particular technology related entrepreneurship, 100% chances are there that there is a patent, but probably you are not able to identify that particular potential patent. And IP audit, it is a process, it is a one what we can say activity that helps you to identify, to mine that particular potential IP. And yes, trademark, each and every what we can say entrepreneurship, generally I will say that it requires trademark. So, it may not, there may not be a what we can say entrepreneurial activity without IP, but there are chances that yes, trademark you can do later also. It is not necessary that in the first year only you have to do trademark registration, you can use it and you can have a trademark later also, but the chances are there that 99% you are having one or the other type of IP, and if you protect it, definitely you are getting the advantage of that particular IP. Then if you want to check something about the what we can say that patent informatics, if you want to check about patent informatics, that particular thing helps you to keep watch on competition competitors. We do competitive intelligence report to keep watch on our competitors, so that we can know that where exactly our competitor is going, and big organizations are doing it very diligently. So, that is competitive intelligence is there. Then patent informatics I am using for prior art search. Suppose I want to develop some certain technology, I will just do landscape and I will try to understand which are the areas where I can explore and I can develop that technology. That is a one way. Then I can use a patent analytics for a invalidity search. Probably these words are little bit new to you, but yes, if I want to invalidate patent of anybody else, I do invalidity search and I can invalidate patent of my competitor, and I can just get a benefit out of that particular thing. Or if I want to file a patent, yes, I do search report, that is I called it as a prior art search, or we call it as a novelty search, and that novelty search is like a like searching relevant patent for which I am the domain in which I am working. So, that novelty search is there, and that gives you the idea about whether really my invention is following the criteria of patent, that is novelty, because that is one of the important criteria for patent. So, that is about the patent informatics. And IP valuation or IP loan, I will suggest you that in roadmap for patent creation, that is the course, You can get the videos about that. In that we have covered in first week these areas in detail. So, if you want to go in details of that, you can refer that particular what we can say session in that course. Now, here further, if I want to elaborate on the IP management system, you can develop your own IP management system and you can self-assess that particular thing. And there are total, I guess, 100 plus or I will say, if I want to say very precisely, there are almost 166 plus minus few one or two processes are there related to IP management, and big organizations are following that particular processes. Now, what are these processes and how exactly that particular thing works? If you want to check, you can check the video on this video is there. You can we will just show you a little glimpse of that, and you can just watch that video and you can get idea, okay, these are the areas when I talk about the IP management system, these are the 15 major processes, and I want to check that in my organization whether I am following that particular what we can say processes, that major processes, whether I am following or not. If you watch this video, you will come to know about that particular thing. So, please watch this video. Then the most what we can say the advantage, the other advantage is that identification of potential IP is a major issue. So, you with the help of this model, if you follow the processes, it will help you to identify the potential IP. Now, the three major things, or we can say that three major questions which will be answered by this IPM model are that how can organization develop their own IPM system, that is IPMS system, how can organization assess their own IPMS system, and how the organizations can manage IPMS efficiently for a wealth creation. So, let us see this model which includes 5 stages and 15 major IPM processes. So, here is the model. If you see this model, you can see that there are total 15 major processes, and then at the upper side you can see that the IP stages are mentioned as pre-IP stage, IP stage, post-IP stage, IP acquisition and IP enforcement as A, B, C, D and E. And within each what we can say the stage, that 5 stages are there, within each stage you can say that in first stage, that is pre-IP stage, you are observing that there are total 5 major processes. In second, that is IP stage, you are observing 4 stages are there, 4 major processes are there. In the third, that is pre-IP stage, you can observe 3 major processes. Then in the D, that is the IP acquisition, you can observe the 2 major processes, and in the last, that is E, you are observing the what we can say 1 process. Okay. Now, how this model is developed? Just now, moving further, we will see a little bit about a IP portfolio. I will just give you the idea so that you can appreciate how entrepreneurship and IP is related. If I give you example of a Siemens, now this organization, can you imagine how many patents are there with Siemens currently? Can you guess? There are 60,000 plus patents Siemens is owning. An organization which is having 3 lakh plus employees across the world, and it is owning 60,000 plus patents, and you just imagine they are not doing patenting activity like a just filed in USA or in India. That is not the case because their market is all over the world. So, they are filing single patent mostly more than 20 to 25 countries, that is or more than that. So, you can imagine the huge IP portfolio that organizations are building, and that they are using, that is a big asset they are owning, and they are using it for the competitive advantage, definitely because they are getting the rights over that particular IP, right. And if I want to compare Siemens, which is what we can say the leading organization in electrical engineering, if I compare it with an Indian organization which is leading in electric engineering, say Crompton and Greaves is there, or Larsen and Toubro is there, this L&T and Crompton and Greaves, if you see and if you see the portfolio, it is can you imagine how many patents they are owning? Not more than 1000. So, the range is between 1000 to 2000. So, you can see the big gap between Indian organization and these international, what we can say the organizations from developed nations, that big gap is there. So, you can just relate that how that what is a gap between IP which is followed in organizations which are from developed countries and in the countries which are developing in nature. IP, that much importance is not given, and probably that will hamper the development or that development of that organization, or they will miss the advantages which are associated with the IP protection. So, that I guess that is this example is good enough for you to appreciate that particular, what we can say the importance of IP and entrepreneurship. Now, when we talk about patent informatics and patent analytics, if suppose we want to go in little bit detail, I have already given you a little bit information about that, but the further information you can get about it is who, when, where and how. Now, what that who, where, when and how is like a, as I have already said that who is like a, who is that particular competitor is there, who is doing that particular activity related to that particular technology, and who is reading your patent. Competitor is a first who is reading your patents, then companies, attorneys are there and judges are there, they are using your what we can say, if that goes into litigation and all that thing, yes, judges are reading your patent, attorneys are reading that patent, but the main reader of your patent is your competitor. So, that information, that is what we can say, whatever information you are giving in patent will be followed obviously by the competitor, and you are also doing that thing. Suppose you know who is your competitor, you can keep watch, that already I have told you, and you can see how exactly their patent portfolio is there and what technology they are concentrating on. Then you can get information about a when, that how it is like a information there in the patent document can be used to know that invention trade, then assignment history. Assignment history in a sense is like that, you know it is a property and therefore, it is transferred by gifts or maybe rights are transferred, and that assignment, that from one owner to another owner, when that particular thing happened, because I can give you the example here, mergers and acquisitions are occurring, big organizations or what we can say within themselves they are what we can say do some activities in collaboration, or there are activities like big organization is completely acquiring startups or small organizations. Now, whenever they are that organization is what we can say acquiring that particular thing, or when they are merging, what the thing is happening, the assignment means probability is that the ownership is obviously transferred. So, when that particular thing happen, obviously that will be noted, and that chronological development whatever is there of that particular technology, you can see by doing the patent analysis. Then where exactly, that geographical locations are very important. If you see any technology, that technology clusters are there, right. So, for example, if I take a India example, Pune is a good hub of a automobile what we can say technology. So, automobile related technology, the technology cluster is based in Pune. So, similarly in what we can say in the country, that technology clusters are there. So, you can get that information, okay, my technology is related to this. Now, where probably I can get vendors, or where I can if I want to develop that particular thing, which area geographical location will be the best and where I can get the solution, that information you can get from the patents. And then the next information say how, that is which are the different approaches or ways which are used when that particular technology is developed, definitely you are getting through the that particular patent. When you read that patent, you will get that particular information. So, Obviously, along with that, this PAT informatics is used in research to avoid duplication of work. Then obviously, for valuation also you can use this patent analytics. If you want to plan your R&D, yes, you will require this patent analytics. Then to manage IP portfolio also you will do patent analytics. And yes, if you are going for any fundraising through bank loans, then at that time also you will require patent analytics. That valuation related exercises whenever done, probably they will do that particular activity. Okay. So, I guess this is good enough for you to understand information about a patent informatics or PAT informatics. Now, if you see IP management, when you are entering into entrepreneurial activity and you want to manage your activity, IP contains areas like generation of IP is there, then protection of IP is there, maintenance of IP is there, and IP commercialization is there. So, these are the what we can say various steps are there, and that particular what we can say the processes you have to manage very well if you want to exploit a maximum benefit from your IP. So, IP management is a what we can say a dedicated domain, and that is particularly used and it is very challenging, especially if your portfolio is a very big, then it is a very challenging to manage your IP. And again, digging out potential IP is the very important, and that activity is what we can say a part of this IP management. Now, moving further, IP strategy, our course is like entrepreneurship and IP strategy. If you know now this whatever we have just discussed, that okay, IP management is there, IP audit is there, PAT informatics is there, IP portfolio is there, these are the different types of IPs are there, and yes, entrepreneurship is totally related to IP and entrepreneurship is I am saying that yes, these are related. Then how exactly you are strategizing your IP protection or maintenance or exploitation, how you are going to strategize that particular thing, because unless until you strategize, you are not going to benefit out of that particular what we can say activity after protection. So, I can give you two examples here, that is a patent thicketing and a cross licensing. So, what that patent thicketing is then? It is like a dense web of a overlapping intellectual properties. So, what happens that it is also called as a patent floods or a patent clusters. It basically means that a specific field of technology, if you are that is your core technology, around that particular patent, which is a very what we can say you are owning it, you are developing a wall or you are developing a fence around it and protecting it, so that your competitor will not reach to your core technology. So, that is one of the what we can say strategy. If you want to be a leader in that particular domain, and you can observe big organizations are following that particular strategy, if their particular core technology is related into that particular X example, you can just imagine, and around that X technology they will not allow anybody to reach that technology, and you can see lot of patents around that particular technology, and this is called as a patent thicketing or fencing also. Now, this is one example. Then I can give you an example of a cross licensing. Sometimes so what happen, there are examples like IBM is a very good example I can give you. It is a leader in IP filing, and I have given you in the first session only how much IP they are filing, and we have compared it with the India filing, right. Now, if you see their portfolio, it is not necessary it is related to only computer. There are many irrelevant patents also that are not related to their business also, but still they are protecting that particular technology. Now, why they are protecting and investing money, time, energy, and that IP personnel is also, human resources also involved in that. So, why they are doing that particular thing? So, they are building that portfolio because one thing is possible, they can license it. If they feel that technology is promising, yes, it is totally unrelated, I can license it and I can make a money out of that. So, that is a one thing. Then there is a cross licensing. What that cross licensing is that, suppose I want to collaborate with somebody. If I want to collaborate with somebody, I can what we can do is like I can say that okay, these are the 5 patents, you can take that 5 patents and in that return you give me that particular technology. So, this is like this is the way by which if there are certain what we can say patents which are maybe in your portfolio which may not be you are not using, but you can do it by using cross licensing, you can take the advantage of a patent. And last, now we will concentrate that what benefits already you have appreciated now. What are the benefits of IP, but I will just quickly give you that what benefits you are getting, you that yes, competitive advantage you are getting. Then this is helping you to create wealth, because either you license, you sell, you develop on your own that product and sell that particular thing, anything you can do, or you can assign it to somebody who can develop and you can get a royalty out of that, anything kind of thing is possible. So, yes, you are getting competitive advantage, you are creating wealth, then it is you are creating asset and you can use it for fundraising. Then when if you have a registered IP, for example, if trademark is there, consumers are getting confidence that yes, this is a trademark, and from that particular, by seeing that trademark, when I say Tata, you will buy products because you know what quality Tata will give. So, it is a trademark. So, that confidence is given, and then the next is like it is giving reward to inventor. So, yes, definitely these are the benefits of a IP. So, with this I guess you are able to appreciate that yes, this IP and entrepreneurship is related, and your entrepreneurial activity will definitely will have one or the other type of IP. Now, in the next session we will see one case study, and I will give you the example that yes, that single patent, that case study is like a single patent which is help inventor to build a giant organization. That is, from single patent a company is incubated by inventor, and a competitive advantage due to patent help to build this giant organization which is worth $1 billion. So, see you in the next session. Thank you.